Good day, Crime Talk aficionados. Guess what? The full bridge guy video has been released from the Delphi homicide case, and we have it here for you. The prosecutors in the Karen Reed case want to limit the defense from saying someone else is responsible for Officer O'Keefe's death. A man who says he had been held hostage since the age of 11 actually sets fire to a house to escape. Luigi Mangione gets a big donation for his criminal defense fund. We have another example of why you meet strangers in public and probably want to do a background search on them. And this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell so that you receive notifications of when we go live or put up new content. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get started, please go to crimetalksearch.com, sign up for that background subscription service today. When you do, you're going to be able to do a background search on as many people as you desire here in the United States, and a report will literally be prepared while you wait. We're talking within minutes, and then that report is emailed to you, and you can get updates on it as well if information changes. And that report that you get emailed to you, it's going to have information on somebody's social media presence, emails, phone numbers that they use. Do they have a criminal history? Are they on a sex offender registry? Do they have liens, judgments? Have they been married and divorced? Everything that you're going to want to know about somebody either coming into your life or somebody that needs to leave your life. All right, let's go ahead and open the docket for Thursday, March 13th, 2025. And first on the docket, Richard Allen. That's right, the Delphi homicide murderer. Attorneys for Richard Allen, obviously the man who is found guilty of murdering the Delphi teens, Abby Williams and Libby German, have filed their notice of appeal in regards to his convictions and released key evidence in the case. Now, obviously, Richard Allen was found guilty last year of murdering the girls on February 13th of 2017. Now, following his conviction, he was sentenced to 130 years in prison, which is the maximum sentence allowed under Indiana law. Now, the March 11th filing comes a little over a month after Allen's attorney submitted a motion to correct errors. The motion details 4 alleged missteps that the defense feels are significant to warrant overturning the jury's conviction and having a new trial. Allen's defense team expressed frustration over the trial's proceedings and their belief that the girl's killer or killers remains free. Now, defense attorneys Jennifer Auger and Andrew Baldwin believe crucial third-party evidence, which they argue could have exonerated Richard Allen, was excluded from the trial. Judge Francis C. Gull ruled there was no link between the suspects the defense wanted to bring to the jury's attention. Now, the jury wanted to convict someone, the attorneys argued. They feel that that is their job. And with no one else to point the finger to, the defense attorneys believe that had their third-party evidence come out, that the outcome would have been completely different. We'll have to wait and see as it relates to how things go on the appeal. That ought to take a year or two. It's going to get interesting. But the big news of the day. Now, this comes from the Justice for Rick Allen website, all right? And they're apparently Transparency and Justice, as they refer to it as. So the attorneys representing Mr. Allen continue to receive considerable and number of inquiries and requests for access to public records and exhibits related to the state of Indiana versus Richard Allen. In response to similar requests, the court has stated that the exhibits are needed for the production of transcripts if the parties request one, and that fulfilling such requests will interrupt the process of guaranteeing the court reporter will be forced to ask the Indiana Court of Appeals for an extension of time to complete the transcript. Recognizing this significant public interest and in the spirit of transparency, this website is going to serve as a central resource for accessing public records, exhibits, frequently asked questions, and updates on Mr. Allen's post-conviction legal proceedings. And all information is going to be provided, according to this website, in accordance with the Indiana Rules of Access to Court Records and the Indiana State Code 5-14-3. And here it is, all 43 seconds, raw video, 43 seconds obtained directly via the extraction performed on Libby German's iPhone. And this was an iPhone 6, and that was done by Sergeant Brian Bunner on February 15th of 2017. Now, what you will notice is that 11 seconds 11 seconds into this video, that's when you see the male come into view. Then everything goes quiet. And 37 seconds shows where they would have basically gone down the hill. Probably the last portion of that video, or moments later, where these girls would have been killed. Now, here's the interesting thing. When you look at that video, the bridge guy video, you can't really make out who that is. But remember, Richard Allen went and said, I was out there that day, which goes back to my point that I've said many, many times on this case. It is always the defendant's own words that get them in the end. Next, an update on the Karen Reed matter. Some more motions were filed. So within weeks to go until her second murder trial is set to begin, prosecutors in the Karen Reed murder case are looking to block her defense attorneys from blaming anyone for her boyfriend's death. So in these motions filed this week in the case, one was from the prosecuting, asking the judge to bar the defense from blaming a third party for Mr. O'Keefe's deaths at trial. It states in the motion, the defense position has chronically been fluid and unsubstantiated, in the words of the special prosecutor, Mr. Hank Brennan. Now, in her first trial, Reed's defense suggested that O'Keefe was killed inside the home where he was found, but never offered a specific theory as to how that may have happened. The defendant has yet to make a proffer of substantial probative value that any other individual is culpable for the crimes. The argument previously set forth by the defendant in pretrial motions contain only vague inferences, rank speculation, and scant details of who, if anyone, had the motive, intent, and opportunity to kill the victim. A third-party culprit is simply a defense tactic to unjustly prejudice the prosecution and to confuse the jury, the prosecutors wrote. Now, Mr. Brennan filed additional motions asking for the defense to be barred from making every reference to bad character or alleged misconduct on the part of any witness without prior court permission. Now, that's referencing the defense tactics at the first trial, according to the special prosecutor, that said that the defense has engaged in a comprehensive campaign to inundate the public with its claims and repeatedly declared or implied that the Commonwealth, the prosecutors, the court, trial court employees, and witnesses are corrupt, declaring that virtually every civilian witness, police officer, and the first responders were somehow complicit in the cover-up of evidence, implying that nearly every witness is a liar. Among those witnesses, Reed's attorneys has pointed to Trooper Michael Proctor, who served as the lead investigator in the case for the Massachusetts State Police. And Mr. Proctor came under fire for inappropriate text messages found on his phone referencing Reed and the investigation, and has faced disciplinary action as a result. Proctor and so many others in this line of work see horrible things every day and may at times need to vent personally. Well, Courtney Proctor, Michael's sister, she said that in a statement to Court TV the other day, who among us hasn't said something regrettable in moments of stress, shock, or sadness? And how would you feel if the contents of your personal phone were questionably released to the public without full context? Anyway, in the statement released Thursday, Proctor's family spoke out on behalf of Mr. Proctor, claiming that he has been defamed, maligned, and falsely labeled corrupt by the alleged murderer, her family, her defense team, and a mob of her followers. Well, motions filed by the defense indicate a continued effort to introduce accident reconstruction experts from ARCA as unbiased and unpaid, despite an invoice and communications revealed at a previous hearing. Now, while witnesses are typically sequestered from the trial and not allowed to view testimony until they have left the witness stand, the defense has filed a motion asking for some of the prosecution witnesses to continue to be barred from the courtroom even after they finish testifying. The defense noted that members of the Albert and McCabe families returned to court after testifying and sat in with O'Keefe's family. Now, Reed and her attorneys are scheduled to return to court on March 18th and into the 19th of March to argue for these motions ahead of her trial, which is scheduled to begin on April 1st. We will have to wait and see how these motions come out. Now, in most cases, we saw this in the Delphi case. We've seen it in the Brian Kohberger case. Normally, if you're going to say that somebody else did something, you actually have to be able to substantiate it. Now, in the Karen Reed trial, in the first case, the defense did an excellent job in raising doubt. They attacked the investigation. They attacked the individual officers as it related to their involvement in the investigation. The question is the judge going to allow it the second time around? Like I said, I've said this before. I'm not a big fan of Karen Reed. I don't particularly like her, but I think that she probably should have been found guilty the first time through. And it's not because I think there's actual innocence there. I think the prosecution failed to prove their case beyond a reasonable doubt. The second time around doesn't usually go well for the defendant after a mistrial. On that retrial, the prosecution gets to fix their problems. They're fixing their problems, ladies and gentlemen. And if you don't think the prosecution isn't fixing their problems, then you are ignoring reality. You are not being intellectually honest in any way whatsoever. And if the judge actually forces defense to say, articulate to me how exactly this happened. Yes, you say a fight took place. Who did it? Why? What motive would have been? It's not like it's this alternate suspect from previous persons that beat up cops when they take them into their house. I think the defense will probably get to swing it again, but guess what? They're going to be ready this time. Prosecution's going to be ready for this. I don't think they saw it coming last time, or they weren't able to put all the pieces together. We'll see how things go. Obviously, Karen Reed is entitled to the presumption of innocence. And if the prosecution fails to prove their case beyond a reasonable doubt, it will be the jury's solemn oath and obligation to find her not guilty. Now, if the prosecution does convince each and every juror beyond a reasonable doubt, it would be their solemn oath and obligation to convict her. Obviously, we still have the issues as it relates to possible sanctions as it relates to the attorneys. I don't think the judge is going to delay this trial. I believe if she's going to impose sanctions against Karen Reed's attorneys, it's going to be after a sentencing in this case, if it gets that far, or if there's an acquittal. We'll have to wait and see. Next, a man started a fire in an attempt to escape from a room in which he had been held captive for more than 20 years, according to police in Connecticut. So the Waterbury police held a news conference Thursday morning to discuss this case. Anyway, the officer said that years in law enforcement, this is probably one of the worst treatments of humanity that they have ever seen, said the chief of police for Fernando Spagnola of the Waterbury Police Department. Now, the man's stepmother, Kimberly Sullivan, was arrested on Wednesday and charged with first-degree assault, second-degree kidnapping, first-degree unlawful restraint, and cruelty to a person, and first-degree reckless endangerment. Now, police investigated Sullivan years ago over treatment of the victim. However, the abuse continued, apparently. Anyway, the people noted that it's shuddering to think that someone would treat any person, let alone a family member or someone who was entrusted with a guardian or a parental figure, the way that this individual was treated. So police revealed Thursday that the first investigation of the family goes back to 2005, when other children told the Department of Child and Family Workers that they were worried about the victim. The victim had been pulled out of school around that particular time. Sullivan managed to apparently hide the abuse, according to the police. And on this case, officers went to the house. It was clean. It was lived in, according to the police chief, the original investigation. They spoke to the victim at the time, and there was no cause for alarm or any condition that existed that would have led officers to believe that anything other than a normal childhood was taking place. They just recently learned, however, that the abuse continued after those investigators left. Apparently, there's a lot of physical therapy that this person was going to have to go through, and there's lots of healing that this person is going to have to go through mentally as well. Now, police said they were called to a home on February 17th for a report of an active fire at a home in Waterbury. The police said two people were home at the time. The owner of the house, Ms. Sullivan, was able to escape safely. And then there was a 32-year-old man, later identified as Sullivan's stepson, who had to be helped out of the home by the police department and the fire department. And police said he suffered from smoke inhalation and exposure to the fire. When speaking to the first responders, though, he said he had to intentionally set the fire in the upstairs room because he wanted his freedom. He lit a fire with some hand sanitizer, some paper from a printer, and he lit that fire while he was locked in the room from the outside. He apparently lit that fire knowing that he could die, but he'd been locked in the room for 20 years, and for 20 years he'd been trying to get out of the room, according to statement by the prosecutors. He also said that he had been held captive by Sullivan since he was approximately 11 years old. Now, the attorney for Miss Sullivan says absolutely not true. He was not locked in that room. She did not restrain him in any way, the attorney argued on behalf of Miss Sullivan. Absolutely not. Anyway, when the man was taken to the hospital, he weighed approximately 68 pounds. He was without exaggeration, to a survivor of Auschwitz, according to the prosecutor. Needless to say, an investigation was launched. Detectives determined that the victim had been held in captivity for over 20 years, enduring prolonged abuse, starvation, severe neglect, and inhumane treatment. He was found in a severely emaciated condition and had not received medical or dental care during the time that he was allegedly held captive. He was also provided with only minimal amounts of food and water, which led to his extremely malnourished condition. The man did tell the police that he was given only 2 cups of water a day and was sometimes forced to drink out of the toilet. He was also held in an 8-foot by 9-foot room. And according to Ms. Sullivan's arrest affidavit, the man was only allowed outside to do chores for his stepmother. Eventually, however, he was allowed to let their dog out, which meant that he was outside of the room for about a minute a day. He was pulled out of school in the 4th grade. He told police that he had no contact with anyone outside the home. And the warrant said that the last reports of basically welfare checks go back to 2005. He said the last time that he left the house was with his father when he was approximately 14 or 15 years old. And according to the arrest affidavit, he told police the threat of losing the minimal food he was given and longer lockdowns kept him from trying to break out. The man also said that only his stepmother, his now deceased father, 2 half-sisters, and deceased grandmothers knew of his situation. Well, Miss Sullivan was arraigned in court. Her bond is set at $300,000. Now, the victim continued to receive treatment at a medical facility. Now, neighbors say that obviously they've never seen the victim. When asked about the fire, they thought, well, maybe it was just an accident. However, the stepmother claimed that she said that she saw a man in the window more than a decade ago. Now, in the backyard, people said that there was a swing set and looked out the back window and just saw a little boy there. And it looked like a little boy to me, according to one of the neighbors. And he just smiled and waved to me and waved back. And he turned his head and looked away and he was gone. Both neighbors said that they were shaken by the news of what has allegedly taken place. And hey, you can't make this stuff up. And, obviously we'll give everybody the presumption of innocence. But if that's in fact what happened, tough situation. But you know who's living the good life? Luigi Mangione. And he's going to live pretty comfortable while he is in custody. And he's going to get those high-powered, expensive New York attorneys paid for. Why, you may ask? Well, a mystery donor has given the biggest donation so far to Luigi Mangione's defense fund, inspired by the quite exceptional support for the man suspected of gunning down the United Healthcare CEO, Brian Thompson. The anonymous giver gave $36,500 this week, topping the previous record of $30,000, which makes a grand total of $722,000 for that criminal defense fund. The nameless benefactor said he or she was quite inspired by the huge swelling of support from a wide cross-section of people for the 26-year-old University of Pennsylvania graduate charged with the murder of the CEO outside of a Manhattan hotel back in December. Apparently, what intrigues me about this case is how unified folks' responses are regardless of strata, the benefactor wrote. Anyway, Mangione's being held without bond in a Brooklyn federal lockup where he receives support from letters and from fans, and while in jail, including photos of many female supporters. Now, the alleged murderer's defense fund swelled after he was rumored to be in a number of sex tapes circulating online. His attorneys, however, say those videos are fake, and that is not Luigi in there. Needless to say, those attorneys got $700,000, not to mention maybe what the families chip in as well. But we'll see at the end of the day if this one goes to trial or if there'll be a plea bargain, maybe jury nullification. I don't know. Everybody's entitled to a defense, ladies and gentlemen, no matter how innocent some people believe somebody may be or how guilty some people may believe they may be. Everybody is entitled to a defense. And whether that's one that they're entitled to by a public defender, if they do not have the means to afford a private defense attorney, or if somebody wants to pay those attorney's fees, guess what? They're entitled to it. Next, another reason why you meet strangers in public. So this is a story about a prom dress sale gone wrong, and it ends up with 3 women in the Gwinnett County Jail down in Georgia. So this incident occurred at a gas station down in Georgia, where an 18-year-old met her former friend, Morgan Flincham, to sell a prom dress. Well, the two women went into the gas station bathroom to try it on when a third young woman grabbed the dress and ran off outside. Police say that's when the victim ran outside and was surrounded by these three ladies. Although the victim's boyfriend was able to get the dress back, a fight broke out amongst these young ladies. And surveillance video from the gas station showed the victim, a mere 102 pounds, 5 foot tall, 18-year-old, flip one of the suspects to the ground after her neck had been grabbed. Now, although the attempted sale took place during the day in a public place with cameras, needless to say, the police and CrimeTalk are saying to do person-to-person sales should take place in designated locations. At least it was in public, right? Don't take other people's things, ladies and gentlemen. Anyway, what's going to happen next? Well, Ms. Morgan Flincham has been charged with battery and theft. Lila DeJager has been charged with battery and theft. And Kaylee George has been charged with theft by taking. I wonder if they're going to get to go to prom. Should they? Anyway, next, this day in legal history on March 13th, 1925, Tennessee passed a law banning the teaching of evolution in schools. The violation of this law by the local school teacher resulted in the famous Scopes monkey trial. And on this day in 1964, Jack Ruby was found guilty. That's right, convicted of murdering Lee Harvey Oswald. You know, the guy that was accused of assassinating President Kennedy. Remember, he was walking out the police, where he's walking out and old Jack Ruby walks up and shoots him right there in front of everybody, basically at the police station. Needless to say, that trial intensified debates about conspiracy theories and our justice system handling high-profile cases. And on this date in 1980, Ford Motor Company was acquitted. That's right, Ford had faced charges for reckless homicide related to the design of the Ford Pinto after a fatal accident. Now, the company, like I said, was acquitted, but it marked the first time a corporation stood trial for homicide in the U.S., obviously influencing corporate liability laws. And next on the docket, our dumb criminal of the day. Yes, an embalmer, ladies and gentlemen, at a Texas funeral home allegedly used a scalpel to mutilate a sex offender's corpse and then stuffed the decedent's severed penis into the mouth. This incident occurred last month at the Memorial Mortuary and Crematory in Houston and has resulted in the arrest of Amber Page Loudermilk. What for, you might say? Abuse of a corpse. A felony. Anyway, investigators have identified the dead man as Charles Roy Rodriguez. He was a registered sex offender who lived in a suburb outside of Houston. Now, Mr. Rodriguez was convicted of sexual assaulting a 31-year-old woman and was basically determined to be a moderate risk, according to the sex offender registry, which lists him as being required to remain on the registry for the rest of his natural life, which we all know he's now dead. Anyway, the court filings, the affidavit for arrest warrant says that within minutes of a funeral company management learning of Mr. Rodriguez's criminal history, an employee told coworkers that she observed Loudermilk cut off the decedent's penis halfway and then stuff it into the dead man's mouth. Now, upon learning of the mutilation, a memorial mortuary and crematory manager went to the cremation room to look for themselves and said, yep, sure enough. Notice that the genitals had been mutilated and the penis was in the man's mouth. The provisional embalmer told the police that she witnessed Loudermilk stab Mr. Rodriguez twice with a scalpel in the groin and then cut his penis off and put it in his mouth. The witness said that Miss Loudermilk said, "You didn't see anything." She perceived that as a threat. Anyway, according to the investigation, the funeral director said she saw Loudermilk fondling the mouth of the decedent, adding that the decedent's penis was in the mouth. Now, Loudermilk, the director said, responded by quickly covering the groin area with a towel and said the decedent had a lot going on with him. Anyway, the judge set Miss Loudermilk's bond at $5,000. And guess what? Not to have any contact with any of the employees that she worked with as an embalmer. while the case is pending. Anyway, the Texas Funeral Service Commission records lists Loudermilk's specialty as an embalmer and her license status as suspended. Oops, there you go. Miss Loudermilk, I get it. Probably got some deep issues here. We'll give you the presumption of innocence, but don't go around mutilating corpses. Kind of in bad taste. Bad taste. No matter what they're accused of doing. It's a little bit in bad taste. And it's really bad taste when you start shoving appendages in people's mouths. Miss Loudermilk, congratulations. You made it. You can put this one on your resume. Dumb criminal of the day. All right, that's all we have for today. Hope you enjoyed the show. Thanks for watching. We'll see you next time. And remember, the Constitution matters.